everyone, good evening or morning for whatever time zone you're watching from. How are you doing? I'm Omotayo Alemero, your digital lawyer. Thanks for subscribing to my channel if you have subscribed. And if you're yet to subscribe, what are you waiting for? Please hit the subscribe button below so you get notified whenever I post new content daily or weekly rather. And you can follow me on Instagram and Twitter at Mydigitallawyer, where I post daily legal tips and tools for business owners and creatives. So quickly today, if you're a software developer or an application developer, this is for you. Computer programmer, this is really for you. This is how to protect your software. Yes, software is also an intellectual property. You might not know, you might just think you're a scientist and intellectual property is just for artists or creatives. You're also creative by creating a software. So stay tuned. So I'm just going to briefly tell you how you can protect that software of yours. Yes, there are rights. You have 4 of them basically. Actually, I'll divide them into 2 segments, 3 on the one side and 1 on its own. You have the patent right, you have the copyright, and you have the trade secrets, right? These can protect the idea behind your software development, while trademark only protects the name or the symbol your software represents. Quickly, in the business of technology and in the science of technology, some people may be exploited, but this is good news. You have rights and you can protect your software in the following way. So let me just go quickly to patent. Patent is the right you have to your innovation, right? So long as you can prove that that innovation is new, it's not obvious, it's an invention, obviously it is new, or it's an improvement on an already existing invention, and you can show that it is industrially applicable, right? So when you build your software, your computer programs, these are innovative stuffs. These are innovations. I really don't have the scientific names for them yet, but these are things that someone thought of. They are technically inclined, science and technology, basically. So when someone thinks of the right programs, the algorithm, how it works, how to connect your interface, how to edit some things, how the programs work online and offline, you know, if you're a software developer, you know what I'm talking about. There's a whole lot that goes behind the scene, yeah? Even the algorithms, everything put together, the technical way you do this, the idea, the innovation you've gotten, the energy you've put in together to bring this new thing to work as a computer program, as a software, can be protected. So if it's a development or an improvement on an already existing work, then you can protect it so long as it is not obvious. It's not something that anyone can think of and just say, yes, it's easy. It's not easy to do, so you can protect that. The next one I would like to look at, the next way you can protect your software as a developer is by protecting its copyright. Now, you would say copyright is the right to your creative works, artistic works, right? And most times when we hear copyright, most people think of authors of novels, writers of songs, or musical artists. Now, in this instance, as a software developer, if you're able to put that creative work, like I said, the technical part of it is protected by patent. The next way you can protect your software as a developer is by protecting its copyright. Now, you would say copyright is the right to your creative works, artistic works, right? And most times when we hear copyright, most people think of authors of novels, writers of songs, or musical artists. Now, in this instance, as a software developer, if you're able to put that creative work, like I said, the technical part of it is protected by patent. But when you put it down in a particular form, even if it's a computer program, codes written down or typewritten, put out in a particular form, that form itself can be protected as your own, that's your software written down, but protected as copyright. And copyright in a work originally, once it's an original creative work of someone, it needs not be registered, but most times I advise that for the sake of full protection, right, you should decide to register that copyright with your local copyright office in your state, wherever it is. You also need an attorney to do that for you. So you should bear in mind that while a patent right can protect the novel idea in that program, right, copyright cannot protect that novelty, that new thing, that idea you have put out in that program, that novel, brand new, if I would like to use that, you have put out to get your work done. What the copyright protects here is the interface, written down, put out in a form. So basic thing about copyright is that if it's not put out in a form, right, it cannot be protected. So it's as simple as that. So you see your computer codes or even written down formats on how you got about this can actually be protected under copyright. For more information on what copyright is, you can check one of my videos. I'll put the link below so you understand what copyright is. Then you see how you can protect your work using your software, right? Using copyright. If you protect your copyright, the owner of a software, a copyright in a software, has exclusive ownership of that software. So even when he's licensing it out, it is still his. If you have a good contract to that, unless you're actually selling out your copyright. So the right to even distribute that software, the right to use it, sometimes if it is not being sold, if you've not gotten that permission to use it, you need to come back to the copyright owner in that software to use that software. So they have exclusive rights to use their software to the exclusion of every other person, whether you're doing business with them or not, so long as there's no contract stating otherwise. You're using somebody else's software that is already protected, you are liable to copyright infringement. Yes, so copyright infringement is not just limited to musical works or works of authors or works written down in a novel. It could extend to software development, okay? And you can protect it if you're a software developer with copyright. So I mentioned patent earlier, I mentioned copyright. Then the next thing I would like to go to is trade secrets. So trade secrets, basically, just like the name implies, are those secrets to your trade, the secret ingredient to your trade. That's in layman's term, not layman. You're not layman. Yeah, intelligent people. So trade secret basically is your own secret ingredient. What makes your own business flourish as against that of your competitors, which you can't really tell anyone. Like if someone is making a perfume, and what makes Gucci perfume smell differently from Touch Oud, or what makes this Indian perfume smell different from a perfume made in Nigeria. What makes your own brand different from that of your competitors? And you really don't want anyone to know about it. Otherwise, if they steal it, you are out of business, all right? So in software development or software creation, you can actually keep your own trade secrets. You can actually protect your software with trade secret. And a trade secret is your formula, a style, a method of doing a particular thing. And every time I talk about trade secrets online or offline, I use Coca-Cola. Trade secret is just like Coca-Cola. When you drink Coca-Cola, taste the difference. That's their logo, right? That's their slogan. Taste the difference. But really, in trade secrets, there's a difference. Only the brand owner knows that. So the difference in making that particular thing. When you take Coca-Cola and when you take Pepsi-Cola, or any other type of cola, you can tell there's a difference. So Coca-Cola definitely has a trade secret protecting their brand. Now here's how it relates to software development, right? As a software developer, if you're really good with what you do, you wouldn't want any other person, even if you have staff, to leak out that particular device or the means of getting out your codes. So even there are thousands and thousands of formula and codes out there, yours might be different from that of another software developer. So unlike patent rights and copyrights, which are subject to infringement, protect your software rather with trade secrets, but it is not subject to infringement. Rather, what you will say is trade secrets are subject to theft. So rather than someone infringing on your rights, it's not really a right per se, it's an intellectual property right, but it's not rights that can be infringed upon. it can be stolen. It can be stolen by someone close to you because it's written down. It has to be documented, obviously, because a company might want to pass it from one person to the other. So there has to be some documented place where the secret to developing this app or this program or this software is written down, right? But then you wouldn't want everyone to have access to it. So the few people that have access to it may actually steal them, or even somebody else, your competitor, might steal that from you. So it's less for you to protect it. Keep it confidential as much as possible. And the only best way to keep such trade secrets confidential is by doing a non-disclosure agreement, an agreement telling your staff or whoever is privy to that information that, hey, look, you mustn't give out this information about this software, about this code, about how I formulated this software to anyone. If you do that, I can sue you, right? So now it's not the trade secret you're suing for. You are suing them for leaking it out, for infringing on the terms of your non-disclosure agreement. I hope I didn't get you mixing it all up in your head. So just know basically you can protect your software by copyright protection or by patent rights, or you can have a trade secret. And the way trade secret works is once you have taken out steps to protect that inventive thing, taking out steps to protect it, write it down, to protect the secrecy in that invention, right? You can actually say no one should leak it out by a non-disclosure agreement. And all of this, you always need an intellectual property attorney, you always need a business law attorney to get it all done for you. So don't just walk down this process of creating a software or building a software without getting an attorney. For instance, you're an upcoming software developer and someone wants to invest in your app, your application, or in your code, or in your creativity. Rather than just give them the entire formula and how you got about this software, you can decide, okay, let's have a non-disclosure agreement. So because this is my trade secret and I wouldn't want it out there, whether you invest in me or not. You can actually suggest that a trade secret is included in your non-disclosure agreement and protected by that. All right, then the next one, which is on the other part, is trademark. I talk about trademark at every given time. So whenever you have a software, the name, if it's a brand, the name or the logo for that software might be protected by trademark if nobody else uses that same name. So now you're not protecting the invention with trademark, you're just protecting your brand. You're protecting the name or the logo or the slogan with your brand, regardless of the fact that it's a software. It definitely should be named because there are so many softwares out there. How do we identify Mr. A's software from Mr. B's software, right? I hope you found this really useful, and if you got it mixed up at any point, please replay this video. If you replay it, watch from start to finish. You will get the gist, definitely. And if you need help, if you're a software developer, you know a software developer who is really confused and trying to get it all right as regards protection, as regards legal steps to protect their software, then get in touch with me. You can send me a mail, mydigitallawyer@gmail.com, and I'll be more than glad to help you. Follow me on Instagram and on Twitter @mydigitallawyer. And before you leave, I'm sure you found this video useful. If you did, just give it a thumbs up, click the like button, and further to that, subscribe to my channel. No, you're not going to pay for it. You just have to hit that button that says subscribe, written boldly right in front of you. You get notified immediately I post new videos. No one has to tell you, no one has to share links with you. All right, I remain Omotayo Alemaru. Till I come your way again next week. Bye.